afternoon, and welcome to the afternoon session of the Court of Appeals. Your panel this afternoon, as it was this morning, is from the Western section. To my left is Judge Carmer McGee from Savannah. To my right, Judge Kenny Armstrong from Memphis, and I'm Judge Arnold Golden from Memphis. Do we have anything we need to address?
None that I'm aware of.
May call the first case.
Meredith Garrett versus Hidden Valley Homes, LLC, et al.
I meant to advise, and I'm sure you're all aware, but the appellant can reserve up to 5 minutes for rebuttal if you just let us know how much of that time, if any, you would like to reserve.
I'll reserve 4 minutes.
All right, you may begin.
Thank you, Your Honors. Appreciate the opportunity to be in front of you. I would just start with saying, in construction.
You need to tell us your name, sir.
Oh, excuse me. May it please the court. My name's Greg Cashin of the Nashville Bar. I would just start with saying, in construction, you have a process for addressing structural issues. Number one, you hire an engineer. Number two, the engineer identifies the problem. Number three, the engineer designs the solution. 4, the contractor prices the solution. Number 5, the contractor installs the solution. This is the process that establishes logic and reasoning for solving structural problems. In our case, we knew that the damages of the plaintiff was for complete demolition of the first of the floor and total replacement of the floor. The floor is a large floor. It's called a foyer, but it's rather large. It's 16 by 22. So I'm taking the deposition of the plaintiff's engineering expert, Keith Garment. And then I ask him, I said, and when you do this type of repair, are you working underneath the house? He goes, yes. I said, okay, so when you do this type of repair, you don't tear everything out and start replacing, putting your drop beam in, do you? He said, no. So my expert, Mark Buchanan, says the same thing. You don't demo and replace. You put a beam up underneath it. He didn't think you needed a beam underneath it, but he said, that's fine. And so they both agreed this was not a structural issue. This was a cosmetic issue. And they both probably have, I would guess, 75 years of experience as engineers. At that point, I know that the plaintiff will fail in her burden of proof because her contracting or construction expert cost the repair of total demolition, and that does not come close to matching what the engineers designed. So basically, she has not carried her burden of proof because she did not link it to what the plaintiff's engineer did. This is a court's abuse of discretion to completely ignore the plaintiff's engineering expert, Mr. Garment, his repair. And then he placed the burden of proof on the defendant, my client, the Spanglers, to suggest that the cost of remediation required by the plaintiff's expert, we should go out and get that. When they can't give it the right thing, he wants us to go find the right answer for that cost. Incorrect legal principles defies logic. So we talk about Mr. Walker, and just suffice to say, if you read through the brief, you know, he said this was a structural problem. He said it's a serious problem. He goes on and he says, I said, did you look at it? He goes, did you look underneath? He says, never. He didn't go up and look at it. He doesn't know what was there. He doesn't know what the structure was. And I said, so did you do any calculations? He said, no, I'm not an engineer. And I assume that you read the report of your engineer. It was read to me briefly. Briefly, I say, and he said, I did not study it. So this man comes in and gives us his opinion orally with not an engineer, and the court buys it hook, line, and sinker. And what we've got here is, on the other hand, the engineers, both of them, review the structure. They both went underneath the house. They performed calculations based on the weights and spans, and they wrote reports with detailed findings. Mr. Walker did nothing. He didn't have a report. He says an expert, but he never gave us his expert report on this and what he was doing. He was in charge of costing and assessing workmanlike conditions. The method of the repair was given to him. That was Garmin's repair. Mr. Walker was only to price the engineer's method of repair. That's the way the system works. Garmin does the method. Walker does the repair cost. And it's not the burden of our client to present what the other Garmin repair is. And we roll this into this confusion. He also said master bedroom had problems. Now we had a small bump, we're going to call it hump, in the floor, which nobody noticed on the plaintiff's side. But in the master bedroom, both engineers testified there's no structural problems. There wasn't even a bump. Mr. Walker tried to say, oh yeah, that went the whole house. The engineers would tell you there was only 2 piers underneath which pushed up. It didn't slope as much because you had too much, they were too stiff. So, you know, if you read the Garmin report, read the Buchanan report, nothing is structural in this case, just cosmetic, no rise, just having a small imperfection in the foyer floor. The preponderance of evidence does not support and cannot support Mr. Walker's repairs. For that reason, it should be. The case should have been dismissed. I made a motion after their proof. They hadn't proved it. They had to cost what was the engineers. They didn't do it. So first, you look at what happens to engineers. They gave an agreed method of repair, and the court ignored them. The court applied a total demolition and replacement when both engineers said it's not necessary. Based on a contractor without engineer training, he was a CAD operator. He was a draftsman. Without calculations, didn't even attempt to do calculations for loads and spans, without even a report. The court placed the legal weight in that man's hands and ignored both engineers, not one of us, both of ours. I know the courts can give weight to engineers, so if we had a battle of the engineers, that would be one thing, sure. Here, you have 2 engineers who agree, and the court ignores them. If affirmed, this decision will invert years of process, logic, and reasoning in the construction engineering community. Engineers will be stripped of their place in identifying problems. Because if this stands, if affirmed, this case becomes the exception to using engineers. This case says, you don't have to use engineers, get your contractor. I teach construction law at seminars. I teach and teach it for 20 years at Vanderbilt as an adjunct professor. And I'll have to try to explain this one to them if this is affirmed. I'll have to try to explain to them why the court on this day stripped the engineers of their opinions and said they're not legal. I don't have to listen to them. A court can sit there and say, 2 engineers agree, I don't have to listen to them. Stripped. So, explaining the engineering opinions, the opinions have no legal value because the contractors, the courts accepted the contractor's untrained opinion to be superior and of more value than the engineers. And this is inverted, this is backwards. So one thing about contractors, I've been dealing with them for years. They always have opinions. And now, they could be given legal weight, more legal weight than engineers. That's what's going to happen if this is affirmed. This will be a well-publicized case of how engineers lost and how you can now cite to this case and say, well, the court doesn't have to listen to an engineer. They don't have to listen to him at all. Even if they both agree, don't listen to him. Because this case will say the court could do whatever it wants to do. And if it wants to ignore engineers, it can ignore it.
Let me ask you, and looking at the order, where do you find that the judge didn't consider the testimony of the engineers? Because as I understand it from the part that I've read so far, I think they all opined that there was some defect that needed to be corrected. And the disagreement was how that was to be done. But the engineering experts didn't opine about the cost to make that correction, as I understand it.
That's true. But the engineers both agreed that you do not rip out the floor and replace it with a brand new floor with a much beefed up structure. That's what they said wasn't necessary.
But they opined that you've got to go underneath the house and do something. What was that something that would be required?
The something was, they called it a drop beam. You would take one beam underneath the house and you would put it up and affix it to the rest of the floor in order to give it support. They said, and as I said, one engineer said it wasn't even necessary. But that's what they're doing. They're not taking out anything. There's no demolition. There's no putback. You're only, both of them said, this was fine, put a drop beam and secure it. That's all. Now, how the judge decided what it was, as far as I can tell from his order, he ignored it. He didn't say, okay, we need to do this. He said, I'm going with the contractor.
Let me ask you, and
Yes,
then in the foyer, there's a marble floor in the foyer?
Yes, sir.
All right, so when you go underneath and you pull out one beam of support, you put in another one, does it not impact in any way the existing floor?
Yeah, that was, my expert said that it had two posts in there. He said, if you take those posts out, it will all come to the same level. It won't be a hump in there anymore. But he said it could crack. The repair that they're talking
So
about.
even if you did what the engineer said, there's going to be some crack in the marble floor. Is that right?
That was my expert. The other expert, the plaintiff's expert, said he wanted to put the drop beam in there. And the drop beam, you would not take out a beam. It would be like a sister beam. It would be with the structure. He would not take out any beams, but he would put that beam the length of the running of the I-joists to give them support. That's what he was going to do.
Okay, but it's not just nailed to the existing beam. It would also have to be on some sort of pier to support the floor above it. Is that right?
Yeah, I think so. I think you'd have to have some support under there since you're going to take out the other beams. But yes, they would have to put a pier both ends. You're correct on that.
All right.
My time is up, and
You'll have your rebuttal time.
Yes, sir. Thank you.
Thank you. Hear from the appellee.
Good afternoon, Philip Robertson. I'm here for the appellee, Ms. Garrett. Structural versus cosmetics been the red herring in this case for the defendants throughout this entire case. Their theory throughout the case was if it's not structural, it's not a problem. The engineers came in, they said, look, it's not going to fall down. It's not a structural issue. The engineers went on to say, we're not concerned about cosmetic. If you look at the testimony, and we printed it out in our brief, the defendants say, look, Mr. Buchanan's is an engineer, not a contractor. It's not his expertise nor his business to estimate repairs. If you go on and you look at what Mr. Garman said, he said, people have me come over to their house, They have problems that bother them. I'm paraphrasing here. He says, but a lot of times people are concerned about cosmetic defects. I'm focused on structural. The crux of this case has nothing to do whether this is a structural or a cosmetic problem. This case involves whether it was a material fact that was not disclosed to my client, of which the defendants were aware. A material fact is not defined as a structural defect. So that in and of itself is a red herring. There's not an issue here as to whether or not this was or was not a structural defect. In fact, even Mr. Walker, the contractor, said, look, it's not going to fall down, but you don't build a house like this. It's not workmanlike. It is a problem with the structure that's causing this hump. And so the issue is not whether it's structural or not. And I would also argue that if this structural is an issue, is what they're hinging themselves on, then how does the engineer's opinion really make much difference at all? They're arguing, well, neither engineer found that it was a structural problem. But what this problem is about the fact that you have cracking tile caused by this hump, and it was not workmanlike. And I think it's really important to point out that the role of the contractor is to talk about what is workmanlike, and his role is not to just decide what the best fix is, although that is one of his roles, but it's the fix not only of the structure but of the entire problem that they're facing. My client's facing an issue, and I think it's important to note the court held the trial at the house. The court watched for hours as Mr. Walker used a laser level and used ropes and, string and measured the hump, showed that it was actually more exacerbated than even the engineer's reports from years earlier. He pointed out the tile. He pointed out the problems that were going to occur. If you look at the engineer's reports, I know that the defendant's engineer said, yeah, you're going to have more cracking if you do this from below. It's also important to look that Mr. Garman said that it was going to be hard to work underneath the house and set the beam, and then goes on to say that's really not my issue as to how the repair occurs. So the court listened to what these engineers said, but the court saw the problem, and the court saw Mr. Walker. Mr. Walker provided the court with the evidence right in front of him. He measured it. He showed the problems of the hump. He took the judge and whatnot through the hallway into the bathroom in the master. He showed where there was the deflection. He didn't go under the house, but he can see how big the crawl space is from looking at the house from the outside. He also knew what the way that the beams ran under the house, despite the fact that he hadn't been under there. So that's all a red herring, the issue with the engineer. I also don't believe that there is anything in the law that somehow puts the engineer above being questioned by a judge. You know, the judge is here to determine what the damages are, and the judge is the one who has the credibility issues, that looks at the credibility. And the judge listened to Mr. Walker. He saw him perform his examination. He gave that examination credibility, and he found that it was the most credible. There's nothing that I've seen in the law anywhere that says that this court's bound to say, well, if an engineer came in here and he gave a fix, even if it's only for a, quote, structural issue, then any and all evidence against that certainly has to be ignored by a judge, or it's going to turn the whole construction world upside down. The issue is, this is a workmanship issue. It's always been a workmanship issue. And it's not only a workmanship issue, it's an issue of what was not disclosed by the contractor in this case, despite the knowledge that they had. And that's not been raised on appeal. It's not one of the issues that you're to determine. So the question is, what they want you to believe is, well, the engineers say there's no structural issue. The engineers say we put a beam in here. The engineers don't care about cosmetic. And so the fact that a contractor who came in here and opined as to workmanlike, which is really the issue under both the theory that we had of implied warranty, and also goes to materiality of what a home buyer or what would affect the market value of this mansion, that's somehow irrelevant. So the court listened to all of that. The court witnessed it. The court's in the best position to give the credibility. And the court found that Mr. Walker provided the most credible testimony as to the extent of the problem, as to the best way to fix that problem, to address not only the fact that there's this hump in the floor that runs through the foyer and right when you walk in the house, but also the fact that you've got tile that's a result of that has cracked and you're going to have continued deflection. But he also addressed what was a workmanlike issue, and that was not addressed by the by the engineers. And that's really what's at issue here. It goes to the materiality and it goes to the workmanlike aspect of the implied warranty, which are the two main claims that the case was brought under and that the court found existed. So you should not just look at what these engineers said, because number one, they limited their testimony to just structural issues as to whether the house is going to fall down or not. The house isn't going to fall down. No one said that. Even Mr. Walker said the house is not going to fall down. But the house has got deflection. Everybody agreed with that. The house has got a hump in it. Everybody agreed with that. Mr. Walker came out and looked at that and measured it, and it's even worse than it was when the engineers years before came in and then had their depositions read by the judge. The judge is in the best place to weigh all of that evidence, and it's not an abuse of discretion for him to determine that, hey, the engineer said it's going to be hard to snake a beam under here. This engineer said it's going to make even worse cracking. Neither engineer addressed the hallway or addressed, the issue with the cracking of the tile. And so who should he look to? He should look to the contractor. And he did. He found that the contractor gave a good estimate. He credited it. He didn't just say, well, I got nothing else to go with here, so I'm just going to go with him. That wasn't the case at all. And so, Your Honors, I think that this is really a red herring when it comes to pointing at the engineers somehow being a untouchable opinion and something that the court was bound to simply because they're engineers, as opposed to a contractor who's actually, his expertise is the means and method of construction. His expertise is workmanship in construction. And those are really the issues that we were dealing with in this case. If you don't have any further questions for me, then I don't think I have anything else to address.
Thank you.
Thank you.
Well, I disagree. This wasn't a structural repair. This was a repair to lower the beam to eliminate the rise, to eliminate the cosmetic.
Let me ask you a question. Is it your position that your client wasn't responsible to replace the, as I understand, there's buckled wood, there's broken tile and marble and whatnot. Is your position that they weren't responsible for that?
I don't recall any buckled wood. There were small hairline cracks in the mortar. This is a 10-year-old house. There could have been small cracks. I mean, if you look at the photographs, there's not anything to suggest this is some horrible thing. And I would just remind the court that you have a rise in the foyer. The plaintiff hired a man named Kenny Greer.
Well, I'm not
sure.
sure you answered my question.
Oh.
If there was cracked marble or cracked flooring or buckled flooring, I'm not sure the extent of it because I haven't seen the pictures yet.
Right,
I haven't had a chance to. Is your client responsible for that?
I think if there was a cracked piece of marble in there, I mean, that's just a repair. I don't think you go out and tear the whole floor out when there's just a small area that they're talking about. And the engineers have figured out a way to address that. So yes, I think if you had a cracked tile that was cracked, not a hairline crack, then yeah, I think the contractor would repair that.
I mean, one of the engineers, if I'm not mistaken from what I've read in the briefs, that said it was gonna be very difficult to get one of these beams underneath the house to make that repair. Is that?
Well, that's an interesting point, because I said, would it be hard to snake that beam under the house? He said, yeah. So I was the one that asked him. He didn't say it's going to be very difficult. I said, would it be hard to snake a beam under the house? He said, yeah, but it can be done. So what you're doing is just pulling the beam under the house, and when you fix it, you're going to take out the piers, so you're going to take out the hump. It wasn't just a structural fix. This was for cosmetics only.
I'm sorry, you call putting in a beam underneath to be cosmetic?
Yeah, because it was going to you had two piers that were causing this small, I call it a rise, two piers. It was going to let it rest. You're going to take those piers out so it would be in the same line with the other I-joists in there. So you're just dropping it down this a half inch.
But you don't consider joist to be part of the structure of a residence?
Yeah, the joist is part of the structure of the residence,
Okay.
Sure.
All right.
I mean, you have to keep your structure together. And that was what they were going to do. They were going to eliminate the hump by lowering that on that drop beam, so they'd have support with your piers that we discussed earlier.
And did your expert opine about what would happen to the marble floor when that adjustment was made?
My expert said he would just take out the piers, but you could have cracking.
You could have cracked.
Could have cracking. My expert. Their expert said the drop beam would eliminate he didn't expect any more cracking on it. So my guy just said, take them out. They're not structural, and just do it. So that was where that was.
When you say take them out, take what out? And it wouldn't be structural?
Take the two piers that are making that small rise. For some reason, they put two piers on two joists, and it left it up. They don't know why they put it down there. It was odd. They said, just take them out. And then you don't have the hump they were talking about. Can I make one?
Go ahead, I'll let you make a short point.
Short point. This whole failure to disclose, I would only point out to you that the only thing you have to disclose is adverse facts. And the definition of adverse, you can read it, it's in 62.13.102. This is not an adverse fact. This is not something you have to disclose. It's a cosmetic. And the cosmetics were all passed up by a guy that did a 71-page report. He didn't see this. The homeowner didn't see it. The realtor didn't see it. It wasn't like it was some battlefield with all this cracked tile and things. So when you talk about failure to disclose, they were within their rights to not disclose a cosmetic defect. That's what we would say.
Yeah, let me ask you, other than Mr. Walker's testimony, do we have any other testimony in the record concerning the cost of repairs?
No.
Thank you.
Thank you. Thank you, gentlemen. We'll take your matter under advisement and issue an opinion as soon as possible.
Thank you, Your Honor.
Thank you. You're free to go. I call the next case.
Jedden Developments, LLC